Hi, my name is Jessie, and I'm a student at the Indigenous Community Legal Clinic, also known as the ICLC, in downtown Vancouver. This video has been recorded on the unceded ancestral territory of the Musqueam, Tsleil-Waututh, and Stolo nations. This video is part of the Lived Law series on end-of-life legalities. In this video, we're going to go over the key requirements to make a valid will and talk about how to ensure that your wishes will be honored after you pass. Please note that the advice in this video does not apply to property on a reserve. If you are a First Nations person who ordinarily lives on a reserve, your will must meet the requirements set out in the Indian Act, which are different than the rules under provincial law. Unfortunately, this video will not cover that scenario, but if you fall into that category, there are resources available to assist you. The Aboriginal Financial Officers Association of BC has written a detailed guide entitled Writing Your Own Will for First Nations people living on reserve. This can be found on the AFOA BC's website under Resources. So, why prepare a will? Before getting into the nitty-gritty of making a will, it's worth discussing why you would want to have a will in the first place. A will is a legal document that states what will be done with your property after you die. It also allows you to name someone, known as an executor, to carry out your instructions, and if you have young kids, to name a guardian to take care of your children after you pass. The benefit of having a will is that it gives you control over what happens to your estate. It can also be reassuring to your loved ones to know your wishes, and it can help to avoid confusion or conflict after your death. Although the process of creating a will can seem quite intimidating, it is actually fairly straightforward. There are only a few requirements you must meet in order for your will to be valid. I will get into those now. In general, for your will to be recognized as valid, it must meet three basic requirements. First, it must be in writing. Second, it must be signed at the bottom by you, the will maker, in the presence of 2 or more witnesses who are at least 19 years of age. And 3, it must be signed by the witnesses in the presence of the will maker, who is you. For a long time, wills had to be signed with everyone in the same room together. However, in response to the COVID-19 pandemic, the government changed the definition of presence to include electronic presence. This means that, at least for the duration of the pandemic, witnesses do not need to be present in person to watch the will maker sign their will. They can do so through video conferencing technologies such as FaceTime, Skype, or Zoom. However, and this is really important, if witnesses are not present in person, they must sign and complete identical copies of the will. If you are planning to do a will signing remotely, it is crucial that you meet this requirement because if there are any differences between the document signed by the will maker and each of the witnesses, the will may not be valid. If you intend to do your will signing remotely, you should check and make sure that this is still valid law, as there is a possibility it may be changed back after the COVID-19 situation is resolved. In general, we would recommend you still try to do your will signing in person if that is safe and possible for you, as that is the best way to avoid any issues with your will's validity. Now, there is one additional requirement for a will to be valid. The will maker must have a certain level of mental capacity in order to make a will. Specifically, the will maker has to be capable of understanding 4 things. They must understand the nature of the act of making a will and its effects. They must understand the extent of the property of which they are disposing. They must be able to comprehend and appreciate the claims to which they ought to give effect. And they must be able to form an orderly desire as to the disposition of their property. Those criteria may sound a little confusing. Fortunately, the courts have helped to clarify the standard. One important thing they've clarified is that the presence of mental deterioration does not automatically prevent someone from having the mental capacity to make a will. They have also told us that testamentary capacity may be present even if the will maker is unable to manage other aspects of their life. In general, the law will presume that a will maker had the requisite capacity and knowledge to make a will if 1. The will was executed in accordance with all of the statutory requirements. 2. The will was read to the will maker before they signed it. And 3. The will maker appeared to understand the will when they read it or read it themselves. What does this mean? Basically, the threshold for mental capacity to make a will is relatively low, and you should not assume that you or someone else lacks sufficient capacity just because they have experienced some degree of mental deterioration. So long as the statutory requirements have been met and the will maker has read and appeared to understand the document, the will may be considered valid, unless someone can present evidence that the will maker did not understand what they were signing. Part 2. Drafting a will. The idea of drafting a will can be intimidating. Fortunately, there are lots of kits and templates available to ensure that you include the right information. That being said, even if you are planning to use a kit to draft your will on your own, it is important that you get legal advice to ensure that your will is valid. Organizations such as LSLAP, the Access Pro Bono Wills Clinic, and the ICLC, if you are Indigenous, can provide free assistance with drafting your will. I will provide contact information for these organizations at the end of the video. How to ensure that wishes will be respected. You may have concerns about whether your will be disregarded or contested. In general, this shouldn't be an issue for you as long as you've chosen someone you trust to be your executor, unless someone can show lack of testamentary capacity or undue influence. However, in BC, spouses or children of the deceased may challenge a will if it does not adequately provide for their proper maintenance or support. This is called a will's variation claim. The way to avoid this happening is to ensure that your will adequately provides for your surviving spouse and/or your children. However, this issue likely won't arise for you unless your estate is quite large, since the cost for a child or spouse to bring a will's variation claim is often greater than any benefit they would get from it. Another way you can ensure that your wishes will be respected is to file what is called a will's notice. This is a short form that you can file with the BC Vital Statistics Agency that states who made your will and where it is kept. You do not need to provide a copy of your will, just explain where it is. Note that there is currently a $17 fee associated with filing a will's notice. The benefit of filing a will's notice is that it makes it easier for your loved ones to locate it after you have passed. They can find it easily by searching the will's registry. It also makes it more likely that your will be respected. If someone applies to probate your estate, they have to do a will's notice search and provide the court with your last will. Part 3. Altering and revoking a will. After you have made a will, you can alter it at any time. However, for your alterations to be valid, you must follow the same steps as if you were making a new will. So, the alterations must be in writing and signed in front of 2 adult witnesses who also put their signatures on the document. In general, it is usually a better idea to draft a new will instead of trying to alter an old one. But if you do intend to alter your will, you should seek legal assistance in order to make sure that your alteration is effective. Also, if you make changes to your will through a new document, which is called a codicil, you should file a new will's notice to register the change. There are a couple of ways you can revoke a will once you've executed it. First of all, if you make and execute a new will, this will automatically revoke all of your previous wills and codicils. Second, you can revoke all or part of your will by making a written declaration saying that you were revoking it. This written declaration must be executed following the same steps as if you were making a new will. So again, you would need to sign it in the presence of witnesses. Finally, you can legally revoke your will by burning, tearing, or destroying the document with the intention of revoking it. However, this option is riskier, as there is a chance that the court will find that you did not have a clear enough intention to revoke the will. So it is always preferable to execute a written declaration, which makes your intentions much harder to dispute. To recap, this video has gone through the requirements to make a valid will, explained some of the ways that you can ensure that your wishes will be respected, and describe the process for altering or revoking a will. If you need assistance with drafting or executing a will, there are a number of organizations that may be able to provide you with free legal assistance. Access Pro Bono runs a wills clinic that offers free legal assistance with drafting and executing wills. To qualify, you must be 55 years and older with a terminal illness and a low or modest income. To get in contact with them, you can start by leaving a voicemail at 604-424-9600 or emailing them at willsclinic@accessprobono.com. Additionally, the UBC Law Students Legal Advice Program, also known as LSLAP, offers free assistance for low-income individuals with drafting and executing wills. Their phone line is 604-822-5791, and they are open from 10 a.m. to 4 p.m. Monday to Friday. Finally, if you are Indigenous, the UBC Indigenous Community Legal Clinic may also be able to assist you with drafting your will. You can reach the clinic intake line by phone at 604-822-1311 or toll-free at 1-888-684-7874. Thanks for watching!
All Live Law Project content is provided by law students for informational purposes only. It is not and should not be considered legal advice. We're not suggesting that you make legal decisions based on any content included as part of this project without seeking legal or other professional advice. We cannot guarantee the accuracy of our content. The information in this project may not apply to you if you don't live in British Columbia or if the law has changed.